Hello, everyone out there in YouTube world, social media world, the world, wherever you might be watching this video from here today. I am musing with MGL as always, and welcome to another edition. As always, before we get started, I'd like to say please like and share if you like my content. Smash that like button down at the bottom. Click the notifications. Subscribe for sure. There's a lot of things going on out there, so the content's probably going to be coming fast and furious. Yes, that movie's stupid, but Fast and Furious. So please like and subscribe. There'll be a bunch of good stuff coming down the pike. So speaking of good stuff coming down the pike, this is a bad stuff coming down the pike. So today's episode is about a very unfortunate ruling that just came out for those of us here in Florida, but it's also going to have wide implications to everyone else across the country. To go in a quick little historical recap, as all of you probably remember, there was Marjory Stoneman Douglas High School that a couple of years ago on Valentine's Day was shot up down in the Miami-Dade, South Florida area. And after that, there was a huge rush to pass some sort of legislation to do something about this situation with gun violence in America and the mass shootings at schools, etc. So in their mad rush, the legislature and our governor at the time, Rick Scott, in a very disappointing move, rushed through and passed through this atrocious bill called the Marjory Stoneman Douglas Act. That bill is full of all kinds of unconstitutional, in my mind, concepts. Red flag laws, et cetera, et cetera. But one of them is at issue here today, and that is the age at which you can purchase a firearm. So it used to be in the state of Florida, just like it is in most places in the country, if you're 18 years old, you're an adult, you can vote, you can serve in the war, et cetera, you could also purchase a firearm. So 18-year-olds were allowed to purchase firearms just like everybody else in the state of Florida. Well, part of the Marjory Stoneman Douglas Act was changing that from 18 to 21. So they upped the age that you were allowed to buy a firearm to 21. So now people who are in the age of 21 in the state of Florida cannot go to a gun shop and purchase a firearm. There's some exceptions in the sense of they can be gifted firearms from family members, etc., and we'll get into that when I read this ruling here. But essentially what it did was make the age of purchasing firearms 21. So at the age of 18, you can serve your country in the military and be given all kinds of firearms. You can vote, you can buy cigarettes, everything else, but in the state of Florida, you can no longer purchase a firearm at the age of 18. You got to wait until you're 21. Well, the NRA filed a lawsuit against that, challenging the constitutionality of it, and it went through the court system, and a ruling just came out a couple of weeks ago, unfortunately upholding that section of the statute. So I'm going to read here. I'm going to go to the ruling and go to an article about it. This essentially comes from a news station here in Florida. It's called Fox 13, but it's on their website. You can find it everywhere. It's a well-known opinion at this point. But I'll read it through here quickly, and then I'll give you my little thoughts on it. So June 29, 2021. While saying the case, quote, falls squarely in the middle of a constitutional no man's land, a federal judge has upheld a 2018 Florida law that prevents people under 21 from buying guns. The 48-page ruling by Chief U.S. District Judge Mark Walker came more than 3 years after the Republican-controlled legislature and then Governor Rick Scott rushed to approve the restriction following a massacre at Parkland's Marjory Stoneman Douglas High School that killed 17 people. The National Rifle Association challenged the constitutionality of the law, which prevented the sale of rifles, shotguns, and other long guns to people ages 18 to 20. Federal law already barred sales of handguns to people under 21. Walker, in ruling last week, traced historical gun restrictions and court decisions and said he was following legal precedent. In part, he focused on a landmark 2008 U.S. Supreme Court case known as District of Columbia versus Heller. While the Heller case is broadly considered a major victory for gun rights supporters, it also said, quote, long-standing prohibitions, unquote, about guns do not violate the Second Amendment, according to Walker's ruling. The Heller case cited prohibitions on such things as felons and mentally ill people possessing guns. Walker concluded that restrictions on 18 to 20-year-old people buying guns were analogous to the restrictions cited in the Heller case. In short, Heller's listed regulations are similar to restrictions on the purchase of firearms by 18 to 20-year-olds. All target specific groups that are thought to be especially dangerous with firearms, he wrote. You hear that, all you 18 and 19-year-olds out there that are getting ready to go off to war? You are a group, according to this judge, that is especially dangerous with firearms. And you are analogous to people who are mentally ill and have felony convictions. But Walker's ruling also raised questions about the law, which would not prevent people under age 21 from, for example, receiving guns from family members. Walker acknowledged a, quote, colossal challenge that lawmakers faced after the Marjory Stoneman Douglas shooting. He said, quote, that said, this court has grave concerns about the balance the legislature struck. While the act appears broad on its face, as defendants, which would be the state, argues, many 18 to 20-year-olds who wish to obtain a firearm will be able to do so through parents or other relatives. Whether this is an effective check on rash decision-making, this court cannot say. But it is clear that this law will have little impact on many, if not most, 18 to 20-year-old Floridians. In short, then, it is not clear how much the act does to prevent tragedies like the one at Marjory Stoneman Douglas High School, end quote. Therein lies the biggest issue here. The judge is acknowledging that this law is going to have little impact on what it's trying to stop. And those are the type of things that those of us in the Second Amendment community always say about these laws. When the gun grabbers come out and they say, oh, we have to do something about the gun violence and we have to save the children, et cetera, et cetera. And then when you look at the laws that they propose and you point out to them, the law that you're proposing is not going to make any difference. It's not going to save any lives. It's not going to change anything. It's not going to accomplish what you want. They don't care. They just want to pass more laws. It's the same thing when it comes to background checks and assault weapons bans, etc., etc. So the judge is acknowledging here that this law, because of what I guess he assumes are probably loopholes or whatever in it that allow you to get firearms from your relatives, it's not going to affect anybody who's 18, 19, or 20 and wants to get a rifle. They'll be able to get one. So the issue is, then why pass the law? Well, again, we know why we passed the law. The judge basically said it was in their haste to do something after the shooting, which is what we always hear, right? We have to do something, even if what we do isn't going to make any difference. This is a horrible ruling. This judge, again, is comparing people who are 18, 19, and 20 to people who are mentally ill, people who are convicted felons, and are specific groups that are thought to be especially dangerous with firearms. So there you go. If you're 18, 19, or 20, you are in the group that's especially dangerous to firearms, according to this judge, and therefore the government has the right to regulate that. And this is one of the problems with the Heller case. We've talked about this in the Second Amendment community for years. It is a landmark decision for firearm rights in that it did establish that it's an individual right. It's not this militia crap that you keep hearing from the anti-gun people who say, oh, it's got to be a well-regulated militia, which is the National Guard. It's not individual people. So it is a very pro-Second Amendment case in that it finally establishes once and for all that it is an individual right, that it has nothing to do with the militia. However, it did carve out all these exceptions that says, well, but the state could regulate it. So they say it's an individual right, but they ignore the shall not infringe part of it and says, okay, it's an individual right, but the state can infringe on it, and it goes through the list, all these areas, mentally ill people, felons, etc., etc. It's one of the reasons why the assault weapons ban from the 1990s was held to be constitutional, because of this whole concept that, you know, you can still regulate around the edges and the state has a compelling interest, etc. It's not an absolute right, despite the fact that it clearly says shall not be infringed. So the Heller decision did leave open a whole bunch of gray areas in the Second Amendment, and now you see a judge here that's actually using what many consider to be a very pro-Second Amendment ruling to be very anti-Second Amendment and take gun rights away from several people. I think you're going to see similar rulings to this when it comes to the challenges to things like the red flag laws, etc., where these judges are going to continue to say that there are certain things that the state can do when it comes to regulating firearms, and they're going to uphold a lot of these things left and right. Maybe when it gets up to the Supreme Court, I assume the NRA is probably going to appeal it, and it's going to go all the way up to the Supreme Court, and nobody quite knows what they're going to do at this particular point. They're taking some Second Amendment cases and they're denying others. A lot of people think, you know, with the conservative bloc that they're going to be pro-Second Amendment, but I have my doubts about some of the judges that are up there. But we'll have to see how it shakes out. But for right now, that atrocious part of that atrocious law has been upheld by a federal judge. So be wary out there, people. Support your organizations. I know a lot of people trash talk the NRA, but they're the ones who brought this lawsuit, paid all the attorney's fees and everything to bring this all the way up to the DCA, and or the federal court. They'll probably bring it all the way up to the Supreme Court too. So even though you don't like them, they still do some stuff, and you need to support Second Amendment groups as long as you can. So unfortunately, it's a bad ruling for us, but we plow on. We'll continue up through the system, and we'll see how the next one shakes out. Hopefully, we'll do better. So thanks for watching. Again, like, subscribe, share, stay safe, stay vigilant, stay healthy, etc., etc. And as always, carry on.